In their new best-selling book, Regime Change, Inside the Imperial Presidency of Donald Trump, New York Times reporters Maggie Haberman and Jonathan Swan describe what Donald Trump's anti-immigration fanatic Stephen Miller was planning if Donald Trump won the 2024 presidential election. Quote, Miller was not a lawyer himself, but he built close alliances with those who were. He had learned from term one that finding the right lawyers was the key to everything. He talked in private about hiring and promoting attorneys with the stiffest spines, no more of what he saw as weak-kneed types who would report back quickly that the president's orders were illegal or who were unwilling to stretch the law to achieve Trump's goals. Miller soon had a second-term remit that sprawled across the government with the most critical new component, his role of overseeing the dozens of presidential decrees the White House would issue in a blizzard of activity in the first week. These included an order to end birthright citizenship that had been dismissed by Trump's first-term attorneys as blatantly unconstitutional. This time, the executive orders would be approved by a new cadre of lawyers, some of whom Miller had personally recruited. Today, the Supreme Court gave those lawyers an F. Donald Trump became the first president in history to attend a Supreme Court hearing to watch when one of his lawyers was disgracing himself to history by trying to argue against the plain language of the United States Constitution on birthright citizenship. That lawyer, Donald Trump's Solicitor General, was cornered into replies to the justices like, quote, I'm not sure, I have to think that through, and, quote, it's a great question, and I'm thinking about it for the first time. And Donald Trump had to listen to Cecilia Wang, the daughter of immigrants who obtained her citizenship by being born in this country, argue in favor of birthright citizenship and in opposition to everything Donald Trump has ever said about it.
In fact, the framers did consider the concept and the actual problems of immigration that were coming up at that time. In addition to this, notable exchange between Senator Cowan and Senator Conness, where Cowan says, if we have this citizenship clause as part of the Constitution, we are going to encourage these gypsies, what he called gypsies, Roma, in Pennsylvania, whom he characterized as invaders, trespassers, and lawbreakers, will encourage them to come into our country because they're children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness, himself an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue of birth without regard to parentage.
The citizenship clause of the Constitution says, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. You cannot ask for more clarity in constitutional prose. As usual, the three Supreme Court justices appointed by Democratic presidents easily passed the basic intelligence test of demonstrating an understanding of what those words clearly mean. They were joined in that understanding by two justices appointed by Republican presidents, Amy Coney Barrett and Chief Justice John Roberts. It was the Chief's prerogative to write the majority opinion, which on page 1 says simply, quote, children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. The majority opinion reached back deep into the history of English common law for the origins of birthright citizenship in American colonial law. Chief Justice Roberts wrote, quote, this common law of citizenship, known as jus soli, or right of the soil, crossed the Atlantic and prevailed in each and all of the states after American independence. As the Civil War approached, more and more southern states sought to deny citizenship to black Americans and openly rejected the common law to reach that result. In the odious decision of Dred Scott versus Sanford, this court imposed the southern states' beliefs onto the nation. Dred Scott was met with shock. The court had overruled the common law, but the people eventually would overrule the court. The Chief Justice pointed out that the Civil Rights Act of 1866 said, quote, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby citizens of the United States. To the Reconstruction Congress, the act was simply assumed to invoke the common law. What the Civil Rights Act began, the 14th Amendment would finish. Like the act, the 14th Amendment was intended to repudiate Dred Scott. This time, however, the goal was even grander, to put the great question of citizenship beyond the legislative power altogether, to settle the issue once and for all. The 14th Amendment achieved its aim. Justice Ketanji Brown Jackson added her concurring opinion to the Chief Justice's majority ruling, saying, quote, I join the court's opinion in full. I write separately to respond to some of the themes in the principal dissent. The principal dissent was written by Justice Clarence Thomas. Justice Jackson wrote, despite his longstanding endorsement of a colorblind constitution, Justice Thomas now surprisingly suggests that the citizenship clause was a race-conscious remedial measure relating only to freed slaves such as Dred Scott and those who shared with them certain characteristics. It is for this reason, he says, that children who were born in the United States but to parents not domiciled here are not entitled to claim birthright citizenship. But that narrow vision of the 14th Amendment bears little relationship to the history of its ratification. Even worse, Justice Thomas's telling elides the entire point of the second founding. The Reconstruction Amendments were an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. And leading off our coverage tonight is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Professor Tribe, I know you've been waiting for this decision, as we all have, since the court agreed to take the case in the first place. Can you explain to us why all 9 justices could not read that simple language of birthright citizenship the same way?
Well, they certainly could read it the same way if they were being honest lawyers without any agenda. Nobody took seriously this strange argument that the 14th Amendment doesn't mean what it says, that the language subject to the jurisdiction thereof means something other than being subject to the power of the United States, which applies to everybody born here, unless they happen to be born in a foreign embassy or in a foreign military encampment. They could all read it. But gradually, what sociologists and philosophers call the Overton window, the range of argument that is considered at least worth taking seriously, gradually that shifted. It shifted because Donald Trump and Stephen Miller wanted to find lawyers who would argue this completely ahistorical position, atextual, ahistorical, inconsistent with what Ketanji Brown Jackson rightly described as the second founding of the country. They wanted to find lawyers who would read it in this odd, different way. And sure enough, they did. I didn't expect this decision to be unanimous. Even before the argument, we knew that there were indications in some of the writings of Clarence Thomas in particular, but also Samuel Alito, that suggested they might come up with some way to agree with the revisionist lawyers. What we did not know, what I think very few people predicted, was that on the basic constitutional issue, this court would rule 5-4. In fact, a lot of the reporting of the decision misses the point. Some of them say, well, it was 5.5 to 3.5 because Justice Kavanaugh dissented only in part. No. He was very clear on the constitutional question. He agreed with Clarence Thomas and with Justice Gorsuch and Justice Alito. And so four Supreme Court justices, just couldn't seem to read the language or the history the way anybody who has studied this subject outside the context of wanting to please Donald Trump and the revisionists understood it to mean. So it was 5-4. That means that we are a heartbeat away from basically repealing the core part of the 14th Amendment, the part that defines what America is, that America is a nation where each human being is valued for him or herself, where it is not who your parents were or where they came from, but who you are. Were you born here? Then you're a citizen. Were you naturalized? Then you're a citizen. It's not a matter of ancestry. It's not a matter of ethnicity or race. And I think Justice Jackson hit the nail on the head when she said it's supremely ironic for the justice who most vividly insists that ours is a colorblind constitution to transmute what was a fundamental principle about being an American into a race-specific remedy for a racially odious decision, Dred Scott v. Sanford. 5-4. It's really, that's the news. That's the sad news.
Justice Alito seems to think that the invention of the jet engine should therefore have changed the Constitution because he believes now that it's just too easy for a pregnant woman to get on a plane and get to this country and give birth in this country and thereby obtain citizenship for that child. But he should know that his ancestors were and ours were coming over to this country on ships now for hundreds of years. Pregnant women were arriving on these shores for hundreds of years from impoverished places on the planet, hoping that there might be more food here than the place they left.
Well, that's true. And he's discovered something that most people have known for hundreds of years. Yes, a pregnant woman can come to the United States of America, have a baby, and that baby is an American. If he doesn't like it, he can propose a constitutional amendment that would get rid of it. But you don't get rid of it by executive order. You don't get rid of it by statute, which is something that Justice Kavanaugh seems to think you could do because he doesn't think the Constitution means what it says. The fact that somebody can come here and have a baby and the baby is an American is part of the nature of this country. We are, to that extent, a country that is built on land, not on blood. They have this idea, the revisionists, that it is the DNA or your ancestry, where you came from. We're all equal. They don't seem to understand that, as Justice Jackson pointed out, the point of this language was to ensure that the promise of the Declaration of Independence about equality was a promise that we could really begin to meet. That's why people think of it as the second founding. The great emancipator, Abraham Lincoln, recognized when he read Dred Scott that was a terrible, odious decision, not just because of what it said about slaves and former slaves, not just because it dehumanized black people in this country, but because it created a caste system. It obliterated the idea that all people are equal. This core idea that the Declaration of Independence said was self-evidently true. But it's not self-evidently true, it seems, to those justices who want to reconstruct a hierarchical society. In fact, the dissenters accuse the Chief Justice and Justice Ketanji Brown Jackson and Justice Barrett and Justice Sotomayor and Justice Kagan of a return to feudalism because they make things turn on the land. They don't seem to understand what feudalism is. The ahistorical character, as well as the legally blind and illiterate character of the dissenting views in this case, is astonishing, but it is frightening because it represents the views of all but one of, it's views of 4 justices. All it takes is a shift of one. That's why I think we really have to think seriously about reforming the court when we have the votes to do it, because the court is now stacked in a direction that is profoundly ahistorical, profoundly anti-constitutional.
Harvard Law Professor Lawrence Tribe, thank you very much for starting off our coverage tonight. Civil Rights Act of 1886. She wrote, Senator Lyman Trumbull's first proposal honed in on the freedmen and provided merely that all persons of African descent born in the United States are hereby declared to be citizens of the United States. If that language had prevailed, the view Justice Thomas asserts today might be well-founded. But Senator Trumbull changed his mind. The day after he submitted that first proposal, he requested to withdraw the original and offer another in lieu of it to the same purport, changing the phraseology. Consistent with the views espoused by activists, Trumbull's new proposal adopted a distinctly universalist register. All persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States without any distinction of color. This is the language Congress would eventually enact as part of the Civil Rights Act of 1866, and the Civil Rights Act of 1866 would go on to become the basis for the 14th Amendment's Citizenship Clause. Senator Trumbull's progression from specific to universal was more than mere word choice. In the face of the virulent anti-immigrant and in particular the anti-Chinese and anti-Romani sentiment of that era, language targeting just freed former slaves would have been the path of least or less resistance. But Senator Trumbull, along with those colleagues who took up the same mantle during the ratification debates, expressly rejected that narrow framing.